Welcome to the Rozanne On Demand CFPB video series, featuring Ontario Systems Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario Systems' corporate efforts in response to the CFPB's launch of compliance examinations in the arm industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome, everyone. My name is Rozanne Anderson. I'm Vice President and Chief Compliance Officer for Ontario Systems. Today, we are going to focus our attention once again on required disclosures under Regulation F. The reason for this deep dive is because e-sign consent, in other words, consent under the Electronic Signatures and Global Commerce Act, is a complicated topic, but it's one we must master in order to comply with Regulation F. Now, as I explained, the Electronic Signatures and Global Commerce Act is a federal law that was enacted in 2000. And the way that it connects with Regulation F is that in Regulation F, the CFPB has made clear that there are requirements for required disclosures if you choose to provide those required disclosures electronically. So if you send the validation notice, the one that would be sent within 5 days of the initial communication, or the response for the request for the original creditor's name, or a request for verification, those three examples are addressed by the CFPB in section 1006.42. And if you choose to provide them electronically, you must do so in compliance with e-sign. So let's take a look at what that means. What is e-sign? E-sign is the law that Congress passed to make clear that we may substitute digital documents and digital signatures for paper documents and pen and ink. The language itself in e-sign is a little bit confusing, but this is what it actually states. If a statute, a regulation, or any other rule of law requires information relating to some kind of a transaction be provided to a consumer in writing, you can only substitute the electronic delivery of that writing if you obtain e-sign consent. Now, e-sign goes on to explain that the consumer must affirmatively consent to the use of a digital delivery mechanism for the required disclosures, and they must respond affirmatively to the following disclosures. First of all, you must indicate whether consumers, if you will, have a right or an option to receive information that we're talking about in terms of these disclosures, to receive information in paper form. You have to explain that. Number two, you must identify whether the consent that the consumer is going to grant you relates to a particular transaction, like one account, or many accounts, or all accounts, for example, held in your inventory for collection purposes. You have to explain their ability and right to withdraw consent at any time, and you have to provide them with procedures to withdraw consent and let them know if there's any negative consequences if they do so. For example, if you're suddenly going to charge them a fee for doing so. I will say in the world of third-party debt collection, even the words coming out of my mouth should send shockwaves. We do not want to charge consumers in any event for their decision to revoke their e-sign consent and go back to paper documents in terms of delivery. So nonetheless, I have to explain that to you because that's a requirement of e-sign. Fourth, you have to describe the procedures the consumer may use to actually update their contact information. In other words, if I would provide you with e-sign consent and tell you that, yes, no problem, I understand the risks, Here is my Ontario System email address, rosanne.anderson@ontariosystems.com. And you may use that to send me information you would otherwise have provided me in writing. I have to know if somehow I no longer have the email address assigned to me by Ontario. I need to know from you, how do I update my contact information so we can keep the e-sign consent in place, but that you will now send the information digitally to a different email address. You also have to explain to the consumer the hardware and software requirements to be able to access and retain the information. If they consent, please send me all the required information, the required disclosures to me via text. You would explain, well, we're going to use a URL. So you have to have the ability to receive text messages on your phone, probably has to be a smartphone. Number two, they have to have the ability and the comprehension that you click on a link in order to go to, let's say, a secure website, and they have to access the document you are sending them. You have to explain all that to the consumer so that they understand what they are agreeing to. And finally, you have to explain to them how to obtain paper disclosures even after they've granted consent and they're not revoking it. They don't say, now send everything to me in paper. They just decide in this instance, for example, the verification information. It would be a situation such as, thank you for sending me all that wonderful verification information about the debt. Now I understand why I owe it. But if they had already consented to e-sign, they could call you, or using any other reasonable means to communicate with you, they could call you and say, well, thanks for the electronic version of that information, but now I want it in paper form. And you would have to honor that. And then finally, I explained a little bit last time, we just touched on it. You need to require the consumer, in that example, you would require me to consent electronically or confirm consent electronically in a manner that reasonably demonstrates that I can access the information in the electronic form you intended to provide it to me in. So, and which is the subject of this whole required disclosure conversation. So now I explained the 7 requirements of e-sign, adding context, extra words, etc. On our website, I have in several locations planted. I've inserted information like sample scripts you may use for e-sign. Let's say if it's going to be a script that you would use on your website or a web portal, or if it's a script your agent would use in a live conversation. We have some samples of that you might want to look at with a very clear understanding that this is not legal advice. It is not ready to use as is. You have to tailor it to your circumstances. But nonetheless, it's a tool to give you something more than a blank piece of a blank email or a blank text. So the last thing to keep in mind, that after you obtain the consent from the consumer to send them these required disclosures to them in writing, if you change the hardware or software requirements, like for example, now if you say, I know you just nailed it, opening up, accessing a document via URL, using a URL and a secure website, but now consumer, we're changing all that. We're just going to attach a PDF. Now, if you're changing kind of what I'm supposed to do based on how you originally explained how I access the required information, you have to explain that to them. In other words, update them if there are any new hardware or software requirements that they would need to actually access. Remember, they have to be able to have actual notice of the information and in a form they may keep and access later. So that's kind of the rest of the story. If things change, you have a duty to explain to them if the software or hardware requirements have changed. If, for example, the way they may exercise their right to revoke consent or request a paper version of something, if any of that changes, you need to notify the consumer. That's part of your responsibility, just as it is part of their responsibility to know how to update their contact information. So that really brings us to the end of the required disclosure section of 1006.42 of Regulation F. The reason I've gone through this information in more detail is so that I actually cover every data point required by e-sign. And you may use this as a tool to begin building your digital communication strategy. Thank you so much for participating in today's video podcast.
Be sure to join us next week for an exclusive webinar where Rozanne will recap the topics she's covered. She'll be joined by special guest John Bedard Jr., Managing Attorney at Bedard Law Group, and together they'll address some of your most pressing CFPB new rule concerns. Register for the webinar today at the link provided below and submit your questions for consideration. Thanks again for tuning into this week's episode of the Rozanne On Demand CFPB video series. As always, be sure to visit the Ontario Systems website for more exclusive events and information regarding the 2021 CFPB new rules.